had to step away and will be back. Mr. Mix. Mr. Bruno states that a right-to-work law is a government regulation that bars employers and labor unions from agreeing to, quote, union security clauses in collective bargaining agreements, end quote. This is a substantially different explanation than the one you've offered, and I note that Mr. Bruno's explanation leaves out employees. I have two questions. First, is a compulsory union membership a government creation? And second, how can employees object to a union security clause in a collective bargaining agreement?
Yeah, the notion of compulsory unionism was developed in 1935 in the Wagner Act after President Roosevelt came to office, and using New Deal powers and the energy of the particular climate at the time, they passed a sweeping labor relations law that now covers private sector workers across the country. We're 80 years into that experiment. So the idea of Section 7 rights under the National Labor Relations Act is really kind of a very interesting preamble to our labor law. It talks about the workers' rights to associate, the workers' rights to bargain, the workers' rights to do all of these things. And it says, believe it or not, it says, has the right to refrain. And if Congress would have put a period there, we wouldn't be here today, because unionism would be voluntary. But they didn't. They said, except to the extent that a worker can be compelled as a condition of employment, as a contract matter, to formally join a labor union. If Congress hadn't have said that at the end, that little phrase at the end of the Section 7 of the Act, we would have voluntary unionism in America. But Congress established this compulsory unionism, saying a worker could be fired if they did not tender dues or fees to a union. 25 states now protect that. The idea of a union security clause, that is a mandatory subject of bargaining. If an employer refuses to bargain over whether or not his employees will be forced to pay dues or fees, or her employees are forced to pay dues or fees, the union can file an unfair labor practice charge against them, saying they are not bargaining in good faith. They must bargain over the union security clause. And frankly, if you're an employer and you look at this and you say, okay, we're bargaining over wages, working conditions, all kinds of things, the one thing the unions put on the table is a union security clause. That doesn't cost me a thing. It simply says I have to force all my employees to pay $38 a month in order to work here. It doesn't hit my bottom line. It doesn't hit the cost of the contract. It's simply something that, one, you have to bargain over, and two, something that the union oftentimes goes on strike over if you don't agree to it, and will file unfair labor practices if you won't bargain over it.
When you were president of AccuTrade, you employed hundreds of people. How did you handle employee grievances at AccuTrade? In your opinion, is union participation necessary to resolve a grievance to the satisfaction of both the employer and the employee?
Well, I don't believe that the union participation was necessary. When we had issues with folks who worked at Ameritrade, we tried to work them out. So, for instance, if somebody had an issue with the manager, they'd bring it to the manager, they'd bring it to that manager's manager, or they'd talk with us. I think what you're really seeing here is it's about the employee's right to choose. How do they want to resolve those issues? And in the company that I was at, we tried to resolve those because we knew that if we had somebody who was a satisfied employee, that person would take care of our customers, and that's how we were able to grow our business. So we didn't need a union to be able to do that. We knew that it was in our best interest to make sure that our employees were happy, so they'd make sure our customers were happy.
Thank you. I want to go back to Mr. Mix. We hear a lot about the issue of fairness around here. Unions have argued that fair share policies that require non-members to pay grievance processing fees are fair. Is this a fairness matter? And you alluded before about employees pursuing their grievances outside the procedures laid out in the CBA. I wonder if you would talk a little bit more about that.
Yeah, just to reiterate, the policy of the Supreme Court, the NLRB, and federal courts has been that individual workers cannot exercise the grievance process outside of union control. The unions own the process. That's literally the words the court have used in talking about the grievance process. But let's talk a little bit more about the fairness of non-members. In a right-to-work state, even in the 25 right-to-work states, in order for a worker to exercise those rights, they have to give up certain workplace rights in order to exercise their personal rights or their political rights. You have to resign union membership in order to exercise your privileges under the right-to-work law. What that means is you can't vote on the very contract that governs your employment. It means you can't vote in union elections. You can't run for union office. You can't participate in union activities at all. So on one hand, you have this Hobson's choice of having to give up your workplace rights in order to protect your philosophical, economic, political rights. That's not fair to begin with, because the union has the monopoly bargaining privilege. They speak for you whether you want it or not. You are forced to associate with them. In the forced unionism states, a worker has to go through that same process and give up those same rights, but can be compelled to pay fees in order to keep their job. That's not fair.
Thank you very much, Mr. Mix. Mr. Scott, you're recognized for 5 minutes.